Defendant is present in court with defense counsel Jim Matthews. We are here for purposes of a sentencing hearing. We were previously in court on November 18th, 2024, where the defendant pled guilty to a lesser included offense of count 1, aggravated assault in violation of 2903.12A1, a felony of the 4th degree. The court found the defendant guilty and ordered a pre-sentence investigation and report, as well as a victim impact statement. The state has had the opportunity to review those reports and is prepared to proceed with sentencing. Thank you.
Mr. Matthews, any reason not to go forward with sentencing?
No, Your Honor.
What, if anything, to say on behalf of your client?
Thank you. Your Honor, we are asking for community control for Mr. Cooper. The offense that he pled to, the aggravated assault, does include a provocation by the victim. And in this case, it is Mr. Cooper's contention that he was struck first in this matter by a headbutt. And admittedly, as he did come in and take responsibility for doing so, he went past the point of defending himself and then became the aggressor in this incident. He did express regret for this in the pre-sentence report. He's 29 years old. He has 3 children that he indicates he supports financially, although there is no child support obligation. And he is a chef at an Italian restaurant, Lago Enoteca, in Ashtabula County. He does have a prior prison history, we understand that. However, he is currently on a supervised release, and to my knowledge has not been sent back to prison on any kind of a violation thus far. He was negative on both of his screens here, and given these circumstances, Your Honor, we do feel that it would be appropriate to place Mr. Cooper on community control.
Thank you. Mr. Cooper, you have the right to address this court before you are sentenced, and you can say anything you want. Is there anything you want to say at this time?
Can I speak here?
You can. No, you don't have to. No, you can stand, sit. No, the court reporter will get down everything you're saying. Just keep your voice up so I can hear you. But
Okay.
that's good.
I appreciate you. I'm definitely apologetic for the victim in the situation. I try to de-escalate the situation at work, and pretty much it just kept going. He was like a friend of mine. I take him to work every day when we work together, so it wasn't just like a random thing that happened. Since then, I continued my job, working and staying at home with the kids and stuff like that. And I feel like I deserve to, be on probation. I could prove any kind of pay stubs or anything like that. And that'll be all, Your Honor.
Thank you. Ms. Ronick, on behalf of the state of Ohio.
Thank you, Your Honor. The state is requesting that the court impose a prison term. The defendant does have a criminal history. He had a felony, attempted assault adjudication as a juvenile, as well as an aggravated trafficking conviction in 2018. He then spent 5 years in federal prison for trafficking firearms, was released in May of 2023, and is currently on federal probation for that offense. The victim in this case did suffer serious physical harm. His nose was fractured in multiple places. He also had lacerations and contusions to his face. 2 other employees of the same establishment gave statements to the police. They claimed that they witnessed the defendant on top of the victim, punching the victim multiple times. Based on all of this, Your Honor, the state is recommending an 18-month prison sentence, and I believe the defendant has 28 days of jail time credit. Thank you.
The court has reviewed the pre-sentence report and investigation and considered the facts and circumstances of the offense involved and nature of the offense. And said here today by Mr. Matthews on behalf of his client, the defendant himself has spoken. Consider what he has had to say, prosecutor's comments and recommendation. I consider all of this in light of the purposes and principles of felony sentencing, which are set forth in 29-2911 of the revised code. The factors in 29-2912, the court finds the victim did suffer serious physical harm. The relationship facilitated the offense between the victim and the defendant as well. Nothing makes it less serious. Obviously, there's the issue of the provocation, but that's built into the charge of aggravated assault. It's an element to that, so the fact that there was provocation doesn't make this any less serious. It's part of the offense for which the defendant pled guilty to. As for recidivism factors, this is the biggest problem, quite frankly. The defendant has a history of juvenile delinquency adjudications, which includes an offense of violence. Then he has a history of criminal convictions as an adult, which also includes a 5-year federal prison sentence that the defendant served 3 of those, 2.5 of those years, and he's been on supervised release. And he was on supervised release when this happened. Violations in federal court right now, one for this offense and one for a positive screen of marijuana, has not complied favorably with previously imposed sanctions ordered by courts. Indicates recidivism is less likely. He got out of prison after serving a substantial amount of time, and within a year later he committed this offense of violence. Evidence in the charge for which the defendant pled guilty to indicates provocation by the victim. The defendant went well beyond the provocation and causing the serious physical harm. The fact that this is an offense of violence with serious physical harm and the defendant's history and being on federal parole can't be ignored by the court. Prison is consistent with the purposes and principles of sentencing. Under 292913B1, the court finds that the defendant did cause physical harm to a person. He has previously served a prison term. The defendant is not amenable to an available community control sanction. Therefore, it will be the sentence of this court that the defendant serve a term in prison of 12 months. You'll be given credit for 28 days, you said?
Yes, Your Honor.
Need to advise you upon your release from prison, you could be placed on post-release control for the state, though it's not mandatory. It's up to the parole authority to decide that. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another, the maximum is 50%, so 6 months, the maximum. Any additional prison term imposed for violating post-release control is being imposed in part of my sentence today. Defendant's order to pay all costs incurred in this action. Is there anything else for the record, Ms. Hronik?
No, Your Honor.
Mr. Matthews?
No, Your Honor. Thank you.